Hello, everyone. Welcome to week 11 of administrative law. This is our final substantive week of the unit, and today we'll be looking at remedies under judicial review. So, for the most part in this course, we've talked about the process of judicial review. We started by looking at when judicial review will be available. Do you have jurisdiction? Is the issue justiciable? Do you have standing? And then from there, do we have enough ground of review available to us to actually point to an error of law in the decision? So, was there no evidence for the decision? Was the decision maker unauthorized? Did the decision go against the purpose of the statute? Did the decision maker fail to take into account a relevant consideration? Did they take into account an irrelevant consideration? Was the person affected denied natural justice and procedural fairness? And on the whole, was the decision just so unreasonable that no decision maker would have made that decision? We've been through that process. We've ticked all those boxes. Now we've got the final step to ask, well, what can the court do about it? What remedy can a court offer to a decision that has been invalidated under one of or more of these grounds of review? So we'll start by talking today about when relief is available and when it's not, because having an available remedy is actually a crucial part of asking for judicial review in the first place. A court is not going to engage with a matter that they can't remedy. Then we'll look at remedies under the Administrative Decisions Judicial Review Act. We'll take a look at remedies under common law, and then lastly, we'll have a think about remedies that are available in equity. So let's start by looking at the availability of relief, because judicial review will only proceed if relief is available. Most of the time, we would expect that relief will be available, and so that won't be an issue, and we move almost straight into the question of, well, what relief are we going to get? But the court does have discretion to refuse relief, and they might do so for a range of reasons. The first would be if relief would be futile. So, for example, if a decision was made that caused a detriment to an applicant, but now having suffered that detriment, the opportunity is lost. There's no way to regain that opportunity, and so setting aside the decision won't give back the opportunity. Then relief is going to be futile, and the court might say, well, there's no point here. You can sort of get around that by arguing that there's no reason not to give relief anyway, just as a test case. But the process is expensive. You might question whether you'd bother in a practical sense. You could argue, the court, I should say, might also refuse relief if the decision will be imminently and lawfully remade in the same way. So, yes, maybe a lawmaker denied the applicant procedural fairness. Maybe they failed to take into account a relevant consideration. But on the evidence, it looks pretty clear that even if the court set the decision aside and sent it back to the decision maker, it would be completely open to the decision maker to make the exact same decision. They just do it properly this time. And so if it's going to be completely pointless and the decision maker will just make the exact same decision again, then, again, we're sort of asking, well, why would you bother in the first place? Conduct or fault of the applicant may also exclude relief. So undue delay, failing to object at the first instance, misleading conduct on the part of the applicant as well, and also attempting to gain a business advantage. These would also be reasons why a court might choose to exclude relief and say, look, yes, the decision maker has not acted properly, has not followed the proper process, but the applicant's not entirely blameless here as well. And so that might be a reason why the court would choose to exclude relief. The nature of the administrative action concerned might also make it difficult or give the court reason not to offer relief. So, for example, decisions by the Director of Public Prosecutions to prosecute, what relief can a court give in that instance? A decision not to prosecute, a court couldn't force the Director of Public Prosecutions to prosecute a matter. So there's not actually a relief that would be available under those circumstances. And so where that is the case, because of the nature of the administrative action, then the court won't actually be able to do anything about it. And lastly, where a more appropriate remedy is available, the courts may refuse to give relief. I guess the best example of that is where merits review is available. Because merits review is more comprehensive, because the tribunal, as we've talked about in this unit, can stand in the place of the decision maker and make the decision itself, then that's a better outcome if it's available to you. And so if merits review is available to an applicant, the court might say, maybe you should try that one first before you come to us, because we don't have as much scope. We don't have as many remedies available to us as under merits review, so try there first. In thinking about the remedies themselves that are available, because throughout this unit we've been focused largely on statutory grounds of review under the Administrative Decisions Judicial Review Act, it makes sense to start with the remedies that are provided for in that act. So Section 16 lists the remedies that a court may, in its discretion, make. And so it can quash or set aside the decision. It can refer the matter to the person who made the decision for further consideration, subject to directions by the court. So, for example, if a relevant consideration has not been taken into account, the court can direct the person to take that into account. Declarations of the rights of parties and directing any of the parties to do or refrain from doing any act or thing which the court considers is necessary to achieve justice. So, for example, directing that the applicant be given procedural fairness or something like that. What is really notable, and we've sort of talked about this already, but what's really notable is that there's nothing in there about the court being able to make a new decision itself, so substituting its own decision for that of the decision maker. Can't do that. And further than that, they can't tell the decision maker how to make the decision. So, under 16(1)(b), referring the matter to the person who made the decision, so, sending it back to them to remake, the court can't tell the decision maker how to remake that decision. And that was made really clear in Minister for Immigration and Ethnic Affairs and Cunningham, where the full federal court set aside orders of a primary judge because the primary judge, in granting relief, compelled the decision maker to remake the decision in a very specific way. So the primary judge said, I'm sending this back to you, decision maker, to remake, and you need to remake it in this way. And that went too far. And so the full federal court on appeal said that's inappropriate. We can only refer it back to the decision maker. We can say, you need to take these things into account, or you need to keep in mind that the purpose of the statute is this and the purpose of the power that you've been given is this, but you can't go as far as saying the decision should be made in this particular way. Section 10, 1 and 3 provide that the rights conferred by the Administrative Decisions Judicial Review Act are additional to any other rights of review. So that includes common law and equitable remedies. So it's worth having a think about those remedies as well. Broadly, they're exactly the same, but they are they're a little bit broader and they can also be a bit more flexibly applied. So that in itself is important. It's also important to consider these because these will be available where the Act doesn't apply. So you'll remember from our topic in week 6 that the Administrative Decisions Judicial Review Act only applies in certain circumstances, and the main one being that a primary legislation can exclude review under the Administrative Decisions Judicial Review Act. Where that review is excluded, you obviously can't use the Act, and so you're forced to rely on the common law process of judicial review. And so if you're going down that pathway, then of course the remedy has to be from common law or equity as well. There's 4 remedies available at common law: Certiorari, Prohibition, Mandamus, and habeas corpus. We'll run through each of those fairly briefly. An order for certiorari is an order to be made certain, and so this aligns with the power under the Administrative Decisions Judicial Review Act to quash or set aside an order. And so an order of certiorari is an order that the record of a decision be moved into the reviewing court so that it can be quashed. So moving a decision made by the executive government under an act into the court, and then the court can quash it and set it aside. And so we can use that to correct a denial of procedural fairness, correct a jurisdictional error, so an unauthorized decision, or errors of law on the face of the record. What's important is that this will only be available where a decision or an order has an effect upon rights. This is not a huge barrier because if you've got standing to challenge the decision, then it's going to be affecting your rights probably anyway. So that's not a massive barrier, but it's something to keep in mind. And what's important is that the decision has to already have been made. So we can't preemptively ask for an order of certiorari if it looks like the decision is going to be made against the applicant. The order has to already be made. And that makes sense because the order itself is moving the order into the court, the decision into the court to be quashed. You can't move a decision into the court if it hasn't already been made. So that's pretty reasonable and straightforward. The second remedy at common law is prohibition, to prohibit, obviously, and it prevents an unlawful decision from being made at all. So this is sort of the flip of certiorari, where the decision hasn't been made yet, but is about to be made, and we get in and we stop the decision being made. So we would use this, for example, to correct a jurisdictional error. So where it looks like a decision maker is about to make a decision where they actually have no authority to make that decision, or where a body is obliged to afford procedural fairness but hasn't followed that yet. So a person has been denied their right to be heard before the decision maker can actually get in and make that decision. We could get an order of prohibition to say, well, you can't make that decision until this person has had their chance to present their side of the case. This also requires rights to be affected, of course. And again, if you've got standing, your rights probably are affected. So that should be fine as well. Mandamus sort of translates to mandate, and it mandates that or compels performance of a public duty that remains unperformed. And so this might be an issue where a decision maker hasn't made the decision yet. You might ask for an order of mandamus in order to compel the decision maker to make a decision. Of course, the sort of initial threshold is that there must be a non-fulfillment or non-performance of a public duty. So that's the threshold step is that there needs to be something that hasn't been done in order to get the remedy to make the person do that thing. What this means is that if there's no duty to exercise a power, so if that power is discretionary, then you can't mandate the use of that power. So a discretionary power can't be the subject of an order of mandamus. It has to be a power that has to be exercised. So in legislation, it might be the decision maker has to make a decision. Then we can get mandamus in order to get the decision maker to make that decision. But if the power is discretionary, the decision maker may issue a license in these circumstances. They also have the discretion not to. Then mandamus will not be effective because you can't compel them to, or you could compel them to exercise the power, but they could choose not to exercise the power. We can seek mandamus on its own, but it is often used in conjunction with other remedies as well. So, for example, with an order of certiorari. So that could be the court uses certiorari to move the decision, a decision that's already been made, into its jurisdiction to quash it. Once it's been quashed, then there's effectively no decision at all. And then you get an order of mandamus to compel the decision maker to remake that decision. So you can see how those two might be used in conjunction. It's interesting, there's no sort of equivalent to mandamus under the Administrative Decisions Judicial Review Act if a decision maker has failed to make a decision. So using Section 10 of the Administrative Decisions Judicial Review Act, which you'll remember says that the decisions at statute are in addition to the common law remedies, you could go for an order of mandamus where a decision maker hasn't made a decision yet as well. Lastly, the court can issue an order of habeas corpus, which is a command to a public authority to release a detained person in the absence of a demonstration of the unlawfulness of the detention. This really comes up in the administrative law context in sort of immigration matters. We haven't spent a lot of time on it in this unit, and so it's not really a common law remedy that we'll focus on, but it is important to be aware that this is a remedy as well that the court can make use of if the need arises. Lastly, let's look at two remedies available in equity. The first is an injunction. You'll probably be sort of aware of these from other courses, but an injunction restrains or compels particular conduct. And because it's under equity, and the rules, of course, are a little bit different under equity, we can use it at the conclusion of proceedings, but we can also use it during proceedings to prevent the decision maker from implementing the decision while the matter proceeds. So an injunction can be sought as an interlocutory remedy while we go through the main judicial process and actually, try and review the decision itself. We might, as a first step, get an injunction to stop a decision maker acting on a decision that they've already made that we want to challenge. Another option is to get a declaration, which is a statement of the legal rights or duties of the parties. For example, a declaration that a party should be afforded the right to be heard under procedural fairness and natural justice, or a declaration that a particular decision maker does in fact have jurisdiction to decide a particular, to make a particular decision. There's a really wide scope for a declaration. It's sort of hard to give too many examples because a declaration can be used sort of for almost anything, but because it's so wide in scope, the court will use it in really specific ways. And so they won't make a declaration that's really broad and sweeping. They will make the declaration really targeted and as specific as possible. So in thinking about asking for a declaration, it's important to think in specific terms in what you're asking the court to declare, rather than a sweeping declaration about the rights or duties of a particular party. That draws our discussion of remedies to a close. And with that, we've reached the end of the substantive elements of this unit. Thank you very much for your attention and hopeful enjoyment in this unit. We will, of course, be doing some revision discussions in week 12, but this is the last bit of content for the unit. So thanks very much, and we'll see you next week to talk about some revisionary matters. See you then. Bye.